So Articles 1 and 2 of the Articles of Confederation, especially Article 2. Article 1 is pretty simple. It's the name for the Confederation, the name for the Confederacy that takes place between the states after or toward the end of the American Revolution and before the Constitution is the United States of America. Now, this idea is not that this is one government to rule them all, to borrow the language of Lord of the Rings, but this is states that are described by that adjectival title, united, that's what they are, not the name of a consolidated central government so much, even though that this is what the name of the Confederacy will be, that they are states who are united in their war effort against Britain, united in their purpose to separate from the British government. There's not a ton here. Article 1 gave this Confederation or League the name the United States of America. Now, before we get into Article 2, it's important to understand the nature of the Articles of Confederation itself. The small sentence here kind of outlines that. And it's impossible to stress too much just how much power that the states had. They were choosing whether or not to ratify the articles. They were choosing whether or not to accept them. It was signing a voluntary compact, in a sense. It was voting to participate in a league based on the state government. Now, this is not a vote of the quote unquote people, in a sense. This is not a vote that where every single person in the state debates and votes. But this is a decision of the state's elected government to see if they will participate in this confederation. And in order to do so, for the confederation to work for them would require them to give up some powers. So there is a risk involved in giving up powers, or not giving them up forever, delegating powers. There's always a risk in delegating powers to others or other entities because they may not use them correctly, they may abuse them, whatever the case may be. Now, how did the states know? What was the guarantee to them? And how did even the Congress of the Articles of Confederation, how did they know what the responsibilities were? How did they know what powers were given to them by the states and what powers were not granted to them by the states? How did they know whether or not, when they undertook to do any action, whether or not that action was legal and permissible and in line with what the states mandated for them to do? How did they know where that line was of crossing into usurpation of the power of the states versus simply doing what the states had allowed them to do? Well, they know because of the agreement, the contract spelled out in the Articles of Confederation. They know because it's spelled out in the document. Unlike the unwritten Constitution of Britain, of England, the unwritten English Constitution, which is a tradition of law and court decisions and a different amalgamation of those things, which develops into this kind of unwritten constitutional law theory, the Americans had a desire within their states, with the Articles and with the later Constitution, of having a written plan and contract mandating the rights and responsibilities of the parties involved. And a written contract, for its flaws, by definition, places limits on interpretation. And so the Articles of Confederation promised that each individual state would maintain control over itself, except in a few specific areas mentioned directly in the Articles of Confederation. So the default position is that the states have the authority of all laws and governance within their borders. The states have all the powers, except for a few and specific areas mentioned directly in the Articles of Confederation. So the default position is that if the responsibility or the legal mandate to do something is not in here, then it remains with the states. And this is spelled out even more clearly in Article 2. You can probably see, if you know the Bill of Rights, the influence that this had on the later Constitution and Bill of Rights. Article 2 says each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this confederation expressly delegated to the United States in Congress assembled. So again, it's indicating that each state retains, continues to hold onto that same level of power and authority. That by hiring on a manager, somebody does not give up their right to the powers that they have and are responsible for. And in the same way, the state, by joining in the Confederation and having the Confederation government manage a few specific areas for it, does not give up sovereignty, freedom, and independence. It does give up a few powers, but they still clearly belong to the states. And it goes on that every power, jurisdiction, and right which is not by this confederation expressly delegated, meaning if it is not clearly written down in words and sentences in this contract, in this document to which the states agreed, then the power is the states alone. And just like someone cannot change without notifying an agreement of the parties, just come back and change the contract without the consent of those who signed it. The government can just change or interpret a change of the articles. So the principle here is that the powers given to Congress under the Articles of Confederation by the states would be expressly delegated, not implied, but expressly delegated. Expressly delegated means there is a list of things they are to do and nothing more. Now, that doesn't negate the possibility of imperfections or gray areas where human writing may have overlooked something. That's okay. But in the case of a legal document involving power, the default is that what is clear is what is written down and what is specifically given over, expressly delegated. Now, later on, this will have an influence on the 10th Amendment, the powers not delegated to the United States by the Constitution, meaning the powers that are not listed in the Constitution nor prohibited to it by the states. So that's a double qualification, that powers not listed and that states have not said we prohibit the US government from doing this, are reserved to the states respectively, or the people. Power remains with the states. States don't make a decision. Will exercise self-government. They make the decision. Now, this will cause some trouble because later on, under the Constitution, Chief Justice John Marshall, with just in a few years, will say the US government may actually do, by implication, whatever it wants, as long as the Constitution did not look ahead and speculate and predict every situation and say the government may not do this. So there's a difference. You may do what is only in the document, or you may do whatever you want as long as the document does not forbid it. How John Marshall will make this argument, with the 10th Amendment being there, the powers are retained to the states or the people if they're not listed in the Constitution. How does he work forward Hamilton's idea of the implied powers doctrine? Well, he goes back and looks at the Articles of Confederation, and he says, the Articles of Confederation said expressly delegated. That means written down and specifically stated. And the 10th Amendment just says delegated. Therefore, according to Marshall's legal reasoning, the government of the Constitution may do whatever it wants, the 10th Amendment notwithstanding, as long as they can interpret it in such a way that the Constitution does not forbid it. And so we see here, not only the Articles become an important foundation or inspiration for the later Constitution, especially in the 10th Amendment, and give us an idea of what the Constitution was intended to be. However, we also see the opportunity for those in power with a written Constitution to interpret for themselves new power that goes beyond the intended limits of a written Constitution.